Well, hi, everyone. Thanks again for joining. This will be Conn Maciel Carey's sixth webinar in our 2023 Labor and Employment webinar series. We're excited to talk today about some hot topics in wage and hour law. I'm joined by my colleague, Mark Ishu. I'm Megan Shaked. We are both members of Conn Maciel Carey's Labor and Employment and OSHA practices. I'll let Mark introduce himself a bit. I'll give you a little bit more of an introduction, and then we will launch right into our topic for the day. And with that, I will toss it over to Mark to introduce himself.
Thank you, Megan. I just joined the firm not too long ago in April. And I come from a very extensive government background. I've worked at the U.S. Department of Labor for over 10 years. I practiced in various areas, including wage and hour. A lot of, as I say, the Department of Labor's bread and butter is wage and hour work. So I have extensive experience on wage, federal matters and administrative matters, matters in administrative court, as well as federal court. In the FLSA and other statutes that are relevant to wage and hour. Before that, I worked at the Illinois Department of Labor doing similar work, just representing Illinois' constituents, and particularly the Illinois laws, which mirror or are very similar to the FLSA and other federal labor laws. With that, I'll turn it over to Megan.
Thanks, Mark. I'm Megan Shaked. I am focused out in our California space. So I am in both our labor and employment practice as well as our OSHA practice. I come to the labor and employment practice with experience in both federal and state litigation, as well as providing advice and counsel to clients on kind of all things wage and hour, and also, all things employment law related, with a natural focus in California. So you'll see throughout the presentation, I'll continue to add the California flavor, since our state tends to have some unique rules, but we're not the only state that does. So we'll try to highlight kind of some comparisons between the federal wage and hour rules and some things that are unique at the state level, and hopefully get some interesting topics covered today. There have been some changes in the last year, and more expected down the line. So just to give you a broad overview of what we'll be discussing today, we will go over kind of two big classification issues. One is whether workers can be properly classified as independent contractors versus employees. And then we will focused on once you're an employee, you're properly classified as an employee, are you properly classified as an exempt versus a non-exempt employee? And we'll talk through those kind of the factors that go into that analysis, and then the impact. What does it mean if you do not properly classify an employee? And then we'll round out the discussion with kind of some miscellaneous topics on making sure that employees are being properly paid. And we'll go over things like, properly compensated time, some updates in the minimum wage and overtime space, and then just some other kind of flags, some other wage and hour issues to make sure that you're thinking about those if they apply to your workforce. And with that, I think Mark's going to get us started on the independent contractor discussion.
So on January 6th, 2021, during the final days of the Trump administration, the Department of Labor published a new rule to determine whether a worker is an employee or a contractor. This is, a constant kind of back and forth as to what to focus on. And under this new rule, there's a 5-factor economic reality test to determine whether or not an employee, the worker, is an independent contractor or an employee. When they issued this final rule, they made clear prior administrative rulings, interpretations, and practices or enforcement policy relating to the classification as an employee or independent contractor are rescinded. In addition, the actual practice of the parties was the more critical focus of the administration, the prior administration. And so the test, as you'll see in a moment, focuses on, that aspect versus what's theoretically or contractually possible. Next slide, please. So what is the test that the Trump administration made as a final rule? The test is, as I said, 5 factors, and the two core factors are what the Department of Labor has mandated as being critical to making the decision as to whether or not an individual is a independent contractor or not. In the first factor, the nature and degree of the individual's control over the work is the focus. So it's requiring the individual to comply with specific legal obligation does not constitute control, whereas in the past it did. So such as setting their own schedule, selecting their projects, and or the ability to work for others, which might include the putative employer's competitors, is what the factor focuses on. And this factor weighs in favor of the individual being an employee under the FLSA to the extent the putative employer, as opposed to the individual, exercises substantial control over key aspects of the performance of the work, such as by controlling the individual's schedule or workload. Requiring the individual, as we said, with specific obligations, it does not factor as it did previously. The second factor is an individual's opportunity to earn profits or incur losses based on their own initiative or management. Again, this weighs towards a finding of employee if the worker can't affect his earnings outside of working more hours or more efficiently. Thank you. The 3 other factors are number 1, I should say the third factor weighs in favor of the individual being an employee to the extent the work at issue requires no specialized training or skill, and or the individual is dependent upon the putative employer to equip him or her with any skills or training necessary to perform the job. The fourth factor, which is listed here as number 2, is the weighs in favor of the individual being an employee to the extent the work relationship is instead by design indefinite in duration or continuous. And finally, the 5th factor, which is listed here as number 3, this factor is different from the concept of the importance or centrality of the individual's work to the putative employer's business. As mentioned previously, the 2021 rule heavily emphasized not only just the first 2 factors, but with the effort to make more employees independent contractors than employees as historically established. Now, to the next slide, Megan, please. Now, there is a new proposed independent contract rule that's been put out there by the Department of Labor. And, it's like a pendulum swinging, one administration to the next, one more conservative to the other. So this is something you have to consider, not just in the short term, but the long term. The new proposed rule returns to what historically has been identified as a totality of circumstances framework to the economic reality test. The rule does away with the core factors as previously identified and lists 6 non-exhaustive factors to be fully and equally considered. These 6 factors are listed here. The first one is whether the worker makes capital or entrepreneurial investments relating to performance of work. And if so, whether such investment relative to the employer's investment indicates the worker is an independent business. The second is the worker's opportunity for profit or loss based on his or her use of managerial skill. The next one is the nature and degree of the control exercised over the performance of work. The next one is the degree of permanence in the work relationship. The next one is the extent to which the work performed is an integral part of the employer's business. And finally, the skill and initiative, including whether a worker uses specialized skills to perform the work. So economic dependence remains the ultimate inquiry for determining whether a worker is an independent contractor. However, the new proposed rule expands the analysis and requires consideration of all the factors that I mentioned, making it harder for, again, the independent contractor classification to survive legal challenge. So it's, again, a pendulum going back and forth. This proposed rule must still work its way through the regulatory notice and comment process before it is formally adopted, and may face legal challenges if and when it becomes final. As always, we will monitor further developments and can help employers navigate increasingly this challenging in the challenging world where these rules have changed quickly. I'm going to turn it to Megan to talk more about California.
Thanks, Mark. So just to kind of orient us in the preparation for a potential swing at the federal level, California went through a shift of its own, but rather than potentially moving towards a totality of the factors kind of test, California moved away from its historic Borrello case, which was an analysis of a whole slew of factors that essentially went to the control factor, but there were various different factors that an employer would analyze in making a decision about whether an employee could be properly classified as an independent contractor. And California, as well as other states, which have done a similar shift, moved to a 3-factor ABC test. And this happened slowly over time. There was a California Supreme Court decision that changed the test, and then it was ultimately codified into California statute. And rather than looking at a whole slew of factors and not having some flexibility, but perhaps not a definitive answer, the ABC test has 3 factors and they must all be met in order for an employee to be considered an independent contractor. And the employer has to establish each of these factors. So 1, that the worker is free from the control and direction of the hiring entity. So that kind of harkens back to some of the control factors that were in our historic Borrello test. The second factor is oftentimes the hardest hurdle for employers to get over, which is that the worker performs work outside the usual course of the hiring entity's business. And then the third factor is that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So moving to this test made it much more restrictive in who could be properly classified as an independent contractor. And as you can imagine, there was quite a bit of pushback from various regulated industries who lobbied the state legislature over a number of years. And there have been quite a few statutory exceptions written into the code to create exceptions for various industries and various occupations. And the way that these exceptions work is that there's many, many factors that go into each one of the exceptions. So if you're wondering, can a certain worker, be properly classified, you have to do a pretty in-depth analysis about what the occupation is, what the statutes say, and if there's any availability for an exception. But then even if an exception applies, the way that the exceptions often work is that they then harken back to a Borrello multi-factor test. So first, you would weigh all of the factors, all of the requirements to classify yourself in the exception. And then if you meet the exception, then you still would go through a multi-factor test to ensure that you can be properly classified as an independent contractor. So that's the kind of the lay of the land in California at the moment. And unlike at the federal level where there may be anticipated changes, there may be some changes to the exceptions that apply. Some of them were in effect only for a number of years or have been extended to allow people to adjust to the new 3-factor test. But generally, this new ABC test has been adopted in California and other states as well. Now, we often get the question of, what does this mean? What are the implications if we get it wrong or we continue to treat somebody as an independent contractor who should be classified as an employee? Well, there's a number of avenues that exist for both, individual plaintiffs to kind of right that wrong, and there are also powers that state agencies have. So, a given worker could bring a civil lawsuit for wage and hour violations if they should have been classified as an employee and they would have been entitled to, say, minimum wage or overtime or meal and rest breaks or other wage and hour kind of benefits. These various benefits that exist for employees who should be entitled to these things, then you can get a kind of regular wage and hour lawsuit brought by a single plaintiff. You could also, skipping down to the 4th line, you could have a class action or a representative action brought essentially for the same claims and perhaps additional penalties. But instead of being brought by a single employee, if you have a large workforce where the decision about whether to classify may impact many, many employees, a whole class of employees, then you could be looking at a much larger lawsuit than just an individual plaintiff. And then agencies also have power to bring, and these look differently. So, an individual worker could bring a claim to state, labor commissioner, for example, but some state agencies also have the ability to enforce these classification rules on their own. And then in a rarer circumstance, you could have third-party personal injury lawsuits if you have the right set of facts. But generally in what we do, we tend to see civil lawsuits either as an individual plaintiff or a representative or class action, as well as individual workers bringing wage and hour claims to the state agencies. So now we're going to transition to talking about another classification issue, but here we're talking about workers being classified as exempt versus non-exempt employees.
Thank you, Megan. What is an exemption? FLSA exemption. For those that don't know, it means that you're not required to pay if your employee is exempt. You're not required to pay them a minimum wage or overtime pay. So that means any hours over 40 hours a week do not have to be paid at time and a half. So how do you have what is involved in an employee being exempt? And I want to go over kind of just a broad overview of the exemptions, and then I'm going to focus on one of them to kind of help you understand how it works and how technically difficult it could be. So there are multiple aspects that one has to consider when determining whether your worker your employee is exempt or not. The first thing you have to look at is how they're paid. There's a test called the salary basis test, which we're going to go into a little more in detail later on in this presentation, but that has to be satisfied in order for you to be able to classify an employee as exempt. So you have to pay them either a salary or a fee basis. And it has to be at a level which we're going to talk a little bit more about later at a standard salary level, which is right now $684 per week. But there's also another component to it, and that's the duties test. And there are various considerations that need to go into evaluating whether or not an employee's duties actually satisfies the exemption. And I'm going to list out, these exemptions as we discuss, what the duties are what duties are required. But the first exemption I'm going to talk about later on more in detail is the executive exemption. But there's also a business owner's exemption, administrative exemption, a professional exemption, a computer professional exemption, and an outside sales exemption. Those exemptions, I urge you to take a look at those exemptions more in detail. You could always consult us to have a better understanding of any of those and whether or not your employees are covered under those. But in general, for all those exemptions, the duties test requires that an employee receive the minimum FLSA compensation requirements, like we went over, and that the employee's actual job duties satisfy the primary duty requirement for their particular exemption. It's important to note that the employee's actual duties and not their job title is determinative. The employee's primary duty is based on the principal, main, major, or most important duty that the employee performs. So that's kind of the general framework to consider when we think about these exemptions. There's also something called the highly compensated individuals test, which we'll talk about a little later. It's similar to a duties test. It's one of those things that you have to consider when you're looking at individuals being paid over a little more over $100,000. There's also some nuanced concepts that you should be aware of. There's overtime only rules relating to retail sales, and there's the Motor Carrier Act, which is basically governs truck drivers. Next slide, please. Now, what better way to look at how technically difficult some of this could be but to look at an example of an employer who thought they were paying someone properly, and they thought that they had an exemption for that particular employee, but it really was not the case, as the Supreme Court recently held in Helix Energy Solutions Group versus Hewitt. This is a case that came down in February of 2023. It's a great case to talk about because it goes through kind of a review of how the exemption process works. But the lessons that we could learn from this, and I'm going to talk about it more in detail so you understand why we can learn them, is number one, there's these exemptions are extremely technical in nature, and they're evolving as your employees' duties change. Whether or not they fit the exemption may change. Another important thing to kind of take out of this case is that the burden is always on the employer. And so employers always need to be proactive to ensure employees meet all the tests necessary to satisfy the exemption. And then finally, another lesson is just because you pay someone a lot of money doesn't mean they can't sue you for not paying overtime. This case is interesting also for those that are more interested in the legal nuances and the way the Supreme Court is made up, because it may relate to a future fight in the Supreme Court as to how to interpret these exemptions. Justice Kavanaugh is very clear in his dissent that that the way the Department of Labor has handled exemptions, particularly the way in which it has promulgated the salary basis test, which we've just identified, is an administrative component and not what Congress had mandated. So he wants to get rid of that whole salary basis test to make it simple for employers to decide. I'm sorry, that was Justice Garouche, but Kavanaugh as well as Alito wanted to simplify it in a kind of a different, more nuanced way. So could we move on to the next slide? Thank you. And here are the facts that go into this so that we have an understanding of what this is about. Helix Energy Solutions Group is an offshore oil and gas company based in Houston. And it had an employee who worked 28, what they call 28-day hitches, living on an offshore oil rig for 28 days at the time and being on duty for 12 hours each day. His pay ranged from $963 to $1,341 per day. He was compensated $248,000, over $248,000 in 15, and over almost $219,000 in 16. So he was compensated pretty well, and the employer thought that he was exempt as an executive that was paid over $107,000. He regularly worked 84 hours a week. He received no overtime pay for hours worked over 40 in a work week. He was also known as a tool pusher supervisor, and that's important for understanding the duties test as we're getting to. Next slide, thank you. So let's talk about this because this is again an example of how all employers need to be careful of how they classify their employees. When we say an employee is paid on a salary basis, the employee must regularly receive each pay period on a weekly or less frequent basis, a predetermined amount that constitutes all or part of their compensation. The predetermined amount cannot be subject to the reductions because of variations in the quality or quantity of the employee's work. And this comes right out of 602A. It's specifically the salary basis test, and it identifies how one should be paid. So you could satisfy the exemption, the salary basis test aspect of the exemption, by satisfying this 602A section. So what does that mean really for you? Employers that make deductions will lose the salary basis exemption for the pay period where the improper deductions were made, and the employees in the same job classification working for the same managers that were responsible for their reductions. So that is something that you have to be very careful and think about. So anytime you pay someone based on the quantity or quality of their work, they're not going to be you're not going to be able to claim the exemption. And there's another test that also is considered, because the regulations recognize that there are different ways to pay, but that specifically you could still be considered exempt. 541.604B talks about compensation. You can satisfy the salary basis test if you pay someone computed on hourly, a daily, or shift basis, rather than a weekly or less frequent basis. An employee may base an employee's pay on an hourly, daily, or shift rate without violating the salary basis requirement or losing the bona fide executive exemption, so long as two conditions are met, which I'm going to go into in the next slide. But before we go there, I want to explain some things, because there's some nuances with all this that are relevant to your practice, your pay practices. And I also want to make it clear that in this Helix case, the focus of the court has been that the 602A and B are not satisfied. And we'll talk about that more as we go through this exemption. But the bonus, when you evaluate pay, you also have to look at whether or not your employees are receiving a bonus. In order to satisfy this test, one important component is whether or not there's a non-discretionary bonus that's more than 10% of the salary level. If there is, then that would negate your ability from establishing the exemption. But it also recognizes, the regulations recognizes that deductions are allowed. And there are 8 deductions kind of that I'll go through just so you're aware. If full day absences from work for personal reasons other than sickness or disability, including vacation, is allowed. A bona fide plan, policy, or practice in place of salary loss due to illness. Example would be you have a sick time policy in effect, but you ran out of sick time, that's allowed. You could deduct for that. If there's jury duty, or you have to go, your employee has to go to court to testify, or military service, you can deduct. Penalties imposed in good faith for infractions of significant safety rules, which kind of parallels our OSHA practice. You can deduct for those. Unpaid disciplinary suspensions, initial or terminal, the initial week you pay an employee, or the terminal week you pay, the last pay period, you could also deduct, given when they actually stop working for you, or when they began working for you, maybe in the middle of the week. Full or partial day absences covered by the FMLA are allowed. And of course, deductions that are required by law, such as payroll taxes. So keep that in mind when you think about the salary basis test. But going back to the Helix case, in this case, they found that 602A was not satisfied. There was no predetermined amount per week. There was no weekly preset. His compensation was based on the quantity of work. Based on the amount of days he worked. So the concept the court was looking at when it interpreted 541 602A, and as you'll see, 604B, satisfy the salary basis test, was that if there was no expectation of a steady stream of pay, then you shouldn't be saying that their employee is receiving a salary such that to satisfy the salary basis test for the exemption. Next slide, please. So we talked about 541 602A, and now I'd like to talk more about the details as to what satisfies 604B. There's kind of two thoughts here, two components. One is the employer must also receive a guaranteed minimum, which kind of is a duplicate step, but what it focuses on, it has to be regardless of the number of hours, days, or shifts of work. Again, the court is looking at, and the regulations kind of lay out the intent such that an employee should be expecting, if they're going to be considered receiving a salary, they should be expecting a constant amount of money for that each week that they work. But in addition, that promised amount must bear a reasonable relationship to the amount actually earned in a typical week. More specifically, I have here, it must be roughly equivalent, this is quoting right out of the case, equivalent to the employee's usual earnings at the assigned hourly, daily, or shift rate for the employee's normal scheduled work week. So here, you can pay per shift, you can pay per day, but that always has to align with the promise that you're going to be paying that employee per week. And it has to have a reasonable relationship. So what you earn daily is equivalent to the promised amount for the week. And so the total amount you pay your employees has to have some form or relationship with the amount of shifts or the amount of the days that you normally work. So there's no significant difference in the amount of money that you're going to be receiving per week. It may be different a little bit under this framework, but it's not going to be significantly different. There's going to be always that expectation that has a bearing of a relationship with the amount of work that you work that week. Next slide, please. So the next slide just kind of lays out what the guaranteed minimum was at the time in which this case, the facts of this case occurred. And at the time, it was a $455 per week. Frankly, it was $455 per week for a long period until January 2020, where it became $684 per week. So in order to satisfy the test, you also have to, as I said, there's kind of some overlap here with 604B, but you have to pay an employee at least $684 per week. And the question is really what it's going to be tomorrow, and we're going to talk about that a little bit down the line. And the third step the court goes through is that for a bona fide executive exemption is the duties test. And we're just focusing on the nature of the employee's job responsibilities. The highly compensated employee exemption applies to employees that earn an annual compensation of $107,432 or more annually. So this includes that 684 I mentioned earlier. At the time of this case, it was 100,000, so it went up a little bit. But that 107,000 it includes commissions and bonuses. For the executive exemption, you could also, let me rephrase, the executive exemption, if you do satisfy an executive exemption, you could also earn less than 107,432, but it's a more rigid, rigorous set of duties tests that you have to satisfy. And let me explain what that is. If you want that exemption and you're paid less than $107,000, employees must have a primary duty of managing the enterprise or department or subdivision of the enterprise. And it's 3 steps or 3 things that they need to do. That's one. The second one is must customarily and regularly direct the work of at least 2 employees. And then 3, must have the authority to hire or fire, or their suggestions and recommendations as to hiring, firing, or changing the status of other employees must be given some particular weight. So in order for you to say that your employee that is making less than $107,432 satisfies the duties test such that you don't have to pay them time and a half or overtime for hours worked over 40, is if they meet all those 3 responsibilities. But if you're paid more or over $107,432, then you don't need to satisfy all 3 of those. Instead, for highly compensated executives, they just have to perform 1. The employee must customarily and regularly perform at least one of the bona fide exempt duties that I just mentioned, either managing their enterprise, directing employees, or having the authority to hire and fire. So there's much more flexibility, and it's much easier to satisfy the exemption if you're paid more than $107,000 or $107,432. And that the idea there is, they understand if you're paid a lot of more money, you should, they believe, the Department of Labor believes that it's more reasonable for you to be to be exempt under the FLSA. Now, there's been let's just go to the next slide. In the fall of 2021, the Department of Labor first formally listed the publication of a new overtime rule in its regulatory agenda. And the DOL sent its new proposed rule to the White House Budget Office for review on July 5th, the last step before it's released to the public. The Wage and Hour then spent several months holding a virtual town hall with employees and employers to gather initial input for the anticipated rule, with an expected publication date of spring 2022. What I want you guys all to understand is that, again, the pendulum has shifted. And for whatever reason, we've been expecting this rule for quite a long time, and it hasn't been issued yet to the public for notice and comment rulemaking, but that it's been in the process for since December of 2021 or the fall of 2021. There's a lot of speculation to why it hasn't been issued yet by the Biden administration, but it could be various reasons. But not to go into that. The rule likely is going to change a lot of things. Of course, it has to be, go through the notice and comment rulemaking, and once it's final, of course, someone's going to challenge it. So it may not become the law of the land for a little bit more, but that said, it's something that's probably going to hit by the end of the year. And so you all have to be ready for it. And what that means is there's going to be a lot of potential changes to the guaranteed minimum. And in the past, the guaranteed minimum was As I said, 455, it went to 684. The Obama administration proposed a higher number, 921, but it wasn't, it was struck down by the federal courts. But likely it's going to increase the amount of what you have to pay your employees minimally per week. Just for perspective, right now, 684 per week is about almost $36,000. So I expect that, it's just a prediction. It's going to go to be around $50,000, but we don't know for sure. So they're going to change for sure the guaranteed minimum, but they're also likely going to change the duties tests. That's the expectation, at least. And the duties test could make it more rigid. Like, for example, there may be a requirement to do like over 50% of your duties, your total duties have to be the three things I mentioned earlier, authority, managing enterprise, etc. And so the important point here, as we transition to the next slide, is that Megan, could you change the slide? Thank you. Is that there's many implications. You're going to have to pay your employees, obviously more money per week, but you have to be careful to not only that, but consider what their duties are as their experience, their tenure at your company continues. And I say that because there's always going to be changes to an employee's duties. And so you have to carefully monitor those changes and make sure that they're still within the boundaries of the exemption that you've understood them to be in. Similar to the Helix case, you had an employer where, you thought you were paying them, more than enough, over $200,000, but they still didn't satisfy it, and they were found to be responsible to pay extensive overtime to that same employee. So although these changes, although they benefit employees, pose a lot of drawbacks for employers who have to either decrease the size of their workforce based upon higher costs. And so keep that in mind as you're evaluating your employees' duties and whether or not they fit under the exemption. And you just so we're clear, you should continue to evaluate exempt classifications as well as independent contractor status throughout the year. It shouldn't be something static because again, these things could change over time. Assistant managers could be promoted as well, but to a manager, and maybe at the time the assistant manager position was exempt, and whoever new comes in, their duties have kind of changed or diminished a little bit in certain ways, and so they no longer fit under the exemption. So we recommend that you do regular audits every year to kind of identify whether or not your employees are within the exemption. And with that, I'm going to turn to Megan to talk about California exemptions.
Thanks, Mark. Really, we added this slide just as a reminder, and this applies, across the board, generally speaking, that whichever jurisdiction has kind of the strictest or most favorable to employee rule, that's oftentimes going to be what applies. So, if you're looking at the federal exemptions, but you have employees, working in states where that they might have more favorable rules towards employees, it's worth checking to make sure that you also meet that state's requirements. California, for example, we know has much higher threshold for minimum wage. So the salary basis test is going to be a bit higher in California. There's also some very subtle differences in they have the same general categories for the exemptions, but as we'll discuss in the next section, there's always some language differences. And so you want to make sure that you're not making any assumptions about whether a worker falls into a qualification for an exemption or not, that you actually go through the exercise of making sure that they do. And, given the nuance and all of the factors that go into all of these analysis, this is oftentimes an audit that, you know, is done by counsel or by people who are familiar with all of the details in all of these tests. But it's definitely worth going through that exercise if these issues are at all an issue for your workforce. And then we'll wrap up the discussion. Don't want to spend too much time. I know we're getting a little bit close to the top of the hour, but we did want to highlight some issues that go towards making sure employees are being paid adequately for their time. And so just kind of a high level discussion for the next few minutes, point out some of the more common claims that we see in wage and hour litigation, and give you some highlights in some ways that we anticipate some changes coming down, particularly in California. So we know kind of generally speaking that employees must receive pay for the time that they work, right? So they have to at least receive minimum wage for the time that they work, and they may be entitled to overtime wages for working more than the threshold requirement. So one thing to note is that there are different definitions at the federal level and then at the state level about what hours worked means. Now, this may seem like a very basic concept. Hours worked are hours that you worked, right? Well, sometimes there are complications that make it trickier than a simple yes or no question. One is, how does the applicable law define hours worked, right? We can just do a straight comparison between the FLSA definition, which is hours worked are those that they're required to be on duty, on premises, or at a prescribed workplace, or time during which an employee is suffered or permitted to work. This would be in comparison to the California definition, which is time during which an employee is subject to the control of an employer and includes all the time the employee is suffered or permitted to work, whether or not required to do so. So the way that this issue is triggered is for things like waiting time. If an employee is kind of on call or has to, stand around at the work site for some amount of time before they are given the thumbs up that they're staying on for the shift, or that raises questions about whether or not they need to be paid for that time. Travel time is an area that has been ripe for litigation in California about whether and when, what circumstances give rise to a obligation to pay for travel time. And meal and rest breaks is also a very common area of concern, when an employee needs to be paid for their rest break and when an employee may need to be paid for their meal break, or when such time can be taken as unpaid. And these are all areas that that could differ from jurisdiction to jurisdiction. Another issue that comes up from time to time is the concept of de minimis time worked. So FLSA recognizes a de minimis rule where infrequent or insignificant time beyond scheduled working hours may not necessarily need to be compensated. Some states may differ on whether that same rule applies at the more local level. For example, California, a couple of years ago in the Troster versus Starbucks Corporation case, tested this concept in whether a store manager who clocks out at the end of his shift but carries the trash out to the dumpster on his way out needed to be compensated for that time of taking out the trash. And in California, the answer was an unwavering yes, absolutely. The de minimis rule does not apply in California. So these kind of subtle questions about what is compensated time need to be looked at employee to employee in case that they may alter how an employee needs to be paid. Another concept that has been questioned in California is rounding practices. So for years and years and years back, I believe there's a 2012 California Supreme Court decision, a Seas Candy decision, that said, rounding was okay if it's neutral on its face and it doesn't result in people not being paid for their time worked. We have seen a number of cases come down that have really brought into question whether rounding practices, no court in California has said definitively that rounding practices are off the table entirely, but they have been subject to a great amount of scrutiny and have really brought into question whether rounding practices should be used at all. In Donahue, they specifically said that rounding should not be used for recording meal breaks, which are required to be recorded in California. And then most recently in Camp versus Home Depot, the California Court of Appeal decided that where the timekeeping system could actually determine the exact amount of time that an employee worked, under those conditions, the employer needed to fully compensate for that time worked rather than relying on a rounding system, even one that was neutral on its face and may not necessarily result in an employee not being paid for all of their time work. So the takeaway has been over the years is that, if you have the ability to determine the exact precise hours that an employee worked, that's how you should be paying them. Same thing with meal and rest periods. There's quite a bit of variety in what states require. I've provided just an example to give you of California. But we know other states have varying requirements for when rest periods do or do not need to be paid, when meal periods may or may not be required and may or may not be required to be paid. So that's something to look out for as well. We've also seen and continue to see changes for breastfeeding accommodations, paid time or break time for nursing mothers. There've been a number of states who have had break time rules in place for quite some time, but we do continue to see additional rules added in states that didn't have them in place to begin with, or haven't had them in place yet. And so that's another thing to keep an eye out about how meal and rest breaks work along with break time for nursing mothers, and making sure that any policies in handbooks or any communications to employees who may request accommodation for a nursing break, that those are all done in compliance with required law. One other, I would be remiss to talk about overtime without pointing out that making sure that the overtime rules that you're implementing are in compliance with FLSA and any state rule. So FLSA, as Mark has mentioned, requires essentially time and a half in excess of 40 hours worked, unless there's an exemption. But note that California, for example, you have to start paying overtime once an employee crosses the threshold of 8 hours of worked in a day or 40 hours in a week. So let's say you have somebody who doesn't work more than 40 hours in a week, but they worked one day for 10 hours and they worked one day for 9 hours, and there's no exemption that would apply to them for overtime. The employer would be obligated to pay that additional daily overtime, even if the weekly overtime threshold was not met. I got a little ahead of myself talking about that before I switched the slide, but you'll have the full information for California overtime for paid and a half, as well as double overtime in the slides. And then just some other, there's quite a bit of subtlety in calculating the regular rate of pay, which comes into play when you're paying overtime. So if you do have workers who are required to be paid overtime, it's worth looking at whether the calculation for the rate of pay for the overtime pay is correct or not. There have been some changes in the law, at least in California recently, about what should be counted in calculating that overtime rate. Things like do bonus earnings need to be included in that rate of pay? How might it impact, how might meal or rest periods impact the rate of pay as well? So these are also issues to just make sure they're getting right, as we know that wage and hour litigation is very common. Wage and hour class litigation and representative action is very common. And so as employers, come into compliance with requirements that are more common, like minimum wage and overtime and meal and rest break claims, we do see plaintiffs' lawyers turning to more of the complicated wage and hour claims to continue to have viable claims moving forward. And then, some other things that often get tacked on in wage and hour litigation, but are again something to just make sure you're getting right, are things like making sure your wage statements are compliant with applicable law, making sure that you're paying your employees timely based on the requirements. We don't see it that often, but sometimes people, they might be paying every other week, or they may be paying twice a month, but the dates don't exactly line up to what a state requires. So it's worth checking. And then making sure that you're keeping your wage and hour records for a long enough time to be compliant with applicable rules. And then we just kind of wanted to wrap up the discussion with just some suggested ways to kind of manage these common compensation and wage and hour challenges. You want to make sure that you have a good system for tracking hours worked, that you're making sure that employees are getting their meal and rest breaks in compliance with requirements. And in this day and age where people might still be working remotely, or people might be in the field, might not be exactly where their supervisor is, that you make sure employees understand their rights to meal and rest breaks, and that their supervisors aren't interrupting those breaks or creating other potential issues with compliance. A couple other things is to remember, if there's a requirement to reimburse employees for reasonable business expenses, for example, California has a labor code section on point, that those are being addressed adequately. If somebody needs to be, reimbursed for their personal cell phone use, or for their use of their car, or various other things that might come up, depending on how your operations work, that's being addressed. And then accordingly, as all of these things change, the law changes or your own practices change, that you make sure to keep any handbooks or written policies updated, that employees or managers enforcing the policies are adequately trained. And then if appropriate, you're conducting an audit of wage and hour practices to catch anything that might need to be updated as well. I won't go into, I want to be mindful of people's time, respectful of people's time, so I won't go too much into the details here, but just a reminder that California, I've made a few references to representative actions. That's, at least in my world, a reference to California Private Attorneys General Act, where employees can seek penalties on behalf of themselves and other aggrieved employees. It's similar, though not exactly the same, as a class action lawsuit, and it brings penalties above and beyond what an individual plaintiff would be able to recover if they brought their own action. So this just has some details about how PAGA works. And we know that that class actions are also common ways for plaintiffs to decide to go after wage and hour violations, and that's not unique to California, the class action litigation. So we want to thank you all for joining us today. We will take a look at the chat to see if there were any questions that came in throughout the course of the webinar, but did just want to remind you all, in case you're not already subscribed to our webinar series, that we have a few more to go to round out the year. And the ones that have already happened, if you missed them, are available by subscribing to our webinar series. You can access the previous recordings. We also do our best to keep our, these are all of our blogs, including our OSHA blogs, but we do try to keep our employer defense report updated with big news items in the labor and employment arena. And so that's always a good resource to check if we've written on a subject and you want to check out what we've said already. And also feel free to reach out to Mark or myself if you have any questions. Our contact information is listed in the webinar slides as well. And again, if there are any other questions, we can reach out to people individually, or you can reach out to us. And we again want to thank you for sharing part of your day with us today, and hope this gets you thinking about ways that you can continue to manage wage and hour issues for your workforce. And yeah, thank you again for joining us.